Hello and welcome back to Supreme Court Now. Today we're going to be looking at two cases that the Supreme Court is hearing this term. The first being the City of Philadelphia versus Fulton, and the second being Niz-Chavez versus Barr. And Barr, of course, is the Attorney General of the United States. So with that, let's get into the cases. So the first case, Fulton versus Philadelphia, we have to look back to 2018 when the Philadelphia Department of Human Services investigated two foster care provider agents for violating Philadelphia's anti-discrimination laws. More specifically, their Fair Practice Ordinance, which is municipal legislation, basically. The reason that these organizations were being investigated was because they refused to work with same-sex couples who wanted and applied to be foster parents. Simply, they refuse to work with same-sex couples because they believe it's against their religion. After the city investigated and inquired with these organizations, they confirmed that one of the agents, Catholic Social Services, who's the petitioner in this Supreme Court case, they agreed. They said, no, we're not going to support same-sex couples because it's against our religion. We're not going to give children to them because we believe it's a sin. So, because of that, and because Philadelphia believes that it's violating their legislation, they stopped referring kids to Catholic Social Services. And of course, CSS then filed suit against the city of Philadelphia, citing that their First Amendment has been violated, specifically the freedom of religion. They're saying we don't have the freedom of religion. We're being restricted by the city to not be able to practice our religion and to work our business, which is the foster care agency, at the same time. And they also cited Philadelphia's Religious Freedom Preservation Act. And this case is a tad bit similar to another case that the Supreme Court saw on October 8th, which is Tanzin versus Tanvir. If you want to look at that one, I'll put it up here just so you have a reference if you'd like to look at it. But it's similar because it shows the difference between, obviously there's a separation of church and state, but sometimes there's a fine line where it can get caught up. And anyhow, Catholic Social Services petition was denied by the District Court of Northern Philadelphia, and their appeal was also denied by the Third Circuit of Appeals, and so now they're pleading to the Supreme Court. However, their case to the Supreme Court, which has been accepted, looks a little bit different. They're going to bring up the Employment Division versus Smith, which is a Supreme Court case from 1989, and they suggest that it should be revisited. The reason they propose this case should be revisited is because in that case, there's two human resources workers in Oregon who worked for the government. And during a particular screening, they both admitted to doing peyote or smoking peyote, eating peyote, I'm not sure, as part of a Native American religion. And because of that, the government fired them, and they were not given unemployment because it was a work-related misconduct. And it was considered a work-related misconduct because, believe it or not, they both worked for a drug rehabilitation center. No irony there, just it is what it is. Anyhow, the Supreme Court ruled in favor of this, stating that the government does hold the right to prohibit the use of drugs regardless of religion. But the bigger picture here is that the government can prosecute the petitioner based on actions they take because of their religion. So if we take this case and apply it to CSS, they're taking action by prohibiting same-sex couples from obtaining foster children, just like Smith and his partner took an action of doing peyote in the name of their religion. So this is why CSS proposes that this case needs to be revisited. And the second argument that the petitioner is going to argue to the Supreme Court is, does the government violate the First Amendment by conditioning a religion's agency by taking actions that contradict with the agency's religious beliefs? So really the bottom line is, can the government, specifically at the municipal level, which is city, apply rules that generally restrict religions to participate in a government program? And so, although it is pretty specific, I think it's a pretty important case to look at. And so with that, let's look at our second case. So the second case, Niz-Chavez versus Barr. And Barr is the United States Attorney General. So let's look to Augusto Niz-Chavez came to the United States unlawfully in 2005 from Guatemala. Let's remember the date, 2005. So now go to 2013. He was served a notice to appear for a deportation proceeding, and he claims, and the records do prove, that the notice did not have the time or place of the hearing. However, a couple months later, he did receive a second notice, which indicated that the hearing would take place on June 25th, 2013. After he got that notice, he applied for a withholding of removal under the Immigration and Nationality Act, which was promoted at the United Nations Convention Against Torture. And this act prohibits an alien's removal to the country where an alien's life would be threatened. So Niz-Chavez's argument here is that if he gets removed, his freedom and his life will be threatened if he has to get deported back to Guatemala. Maybe he is, in some shady stuff down there, politics, gangs, who knows. But that's going to be his argument. So he gets a merits hearing for his application of removal, but this hearing is not even held until 2017. So let's pause for a second. It's 2017, so he's been in the United States for 12 years. So his argument now is that in Chapter 8 of the United States Code, Clause 1229, states that an individual is eligible for cancellation of removal if he or she has been physically present in the United States for a continuous time of not less than 10 years. So his argument now is that, look, I know, although I had a hearing in 2013, I've now been in the United States for 10 years because it's 2017, and I've been here since 2005, so I'm eligible for this cancellation of removal. It says so right here in the United States Code. And however, there is a big if here. The accrual of time in the United States actually stops when the alien is served a notice to appear, and this clause is called the stop time rule. So the stop time rule was basically, let's look at a hypothetical, right? Say I'm an illegal alien who's been in the United States for 9 years and 11 months. But right before the clock hits 10 years in that 11th month, I get a notice to appear in front of a judge for a deportation proceeding. I can't just ignore the notice for 1 month until I get to that 10 years and say, hey, I've been here for 10 years. I'm past that threshold. I'm eligible for cancellation of removal. So that's why the government created this stop time rule. So immigrants can't just ignore the hearings until they hit that 10-year mark and think that they are in the clear. So Niz-Chavez's appeal was denied by an immigration judge because the immigration judge cited that, look, the stop time rule was triggered in 2013 when he got the first notice. However, once Niz-Chavez appealed to the United States Board of Immigration Appeals, because if you'll remember, his initial notice did not have the date and time, but he did get a second notice that had the date and time of the appearance. And so Niz-Chavez is going to cite a 2018 Supreme Court case, Pereira versus Sessions. And in this case, the Supreme Court ruled that in order for the stop time rule to be triggered, the notice sent to the immigrant must have the date and time of the hearing. However, Niz-Chavez did receive a date and time on that second document that he received a couple months after the first one. And so the question that the court is going to have to look at is, in order to trigger the stop time rule, does the government have to serve one specific document with all the necessary information, or can the government serve as many documents as needed to supplement all information? And so that's that. But if you don't mind, I want to tack on my 2 cents of why this is an issue and why this has been an issue in the Supreme Court multiple times. Our immigration department is very overwhelmed. I mean, it's no secret that it takes years to become a citizen, and another repercussion of just the sheer traffic that this department gets is that's one of the reasons that they send out multiple notices of hearings and without the correct court date and time. Because you saw, like with Niz-Chavez, his hearing didn't even take place until 4 years after the original notice. So in the immigration department's eyes, I mean, they can save paper, they can save time and money by not putting the date and time, because it's likely to get changed anyways. The initial court date that they put is probably not going to happen anyways. They're so jam-packed with all these other hearings going on. So, I mean, regardless, rules are rules and they must be followed. So, the Supreme Court needs to decide on how this should go. And so those are all the cases for today. If you'd like to learn more about the Supreme Court or look at more of the cases that they're looking at over the 2020 through 2021 term, go ahead and check out my channel. I'm covering every court case that they're looking over this term. And with that, thank you guys for watching, and adios until next time.